My name is Bill Bay, and I am chair of the ABA section of litigation. The section of litigation is proud to present this program, the 50th anniversary of Gideon versus Wainwright, and we do it from Florida, where it all began. I would like to acknowledge publicly the work of Robin Mayer in putting together this program. She has served as the director of the American Bar Association's Death Penalty Representation Project since 2001. The accomplishment of that project and the contributions of Robin to our profession are extraordinary. The section of litigation is a proud sponsor of that project. 50 years ago, a prisoner in a Florida jail received the news that his case had changed the world for criminal defendants everywhere. Never again would a poor defendant stand in a courtroom facing possible jail time without a lawyer at his side. In Gideon versus Wainwright, the U.S. Supreme Court found a Sixth Amendment right to counsel for criminal defendants who were too poor to hire their own lawyers. Today we're here in Florida, where it all began, to reflect upon the significance of this decision. It's an important opportunity to evaluate how the criminal justice system has been positively affected by the lawyers who became an essential part of ensuring justice in criminal cases. But we must also acknowledge the ways that we have fallen short of what is promised and what was promised. Most importantly, I hope today's discussion can identify how members of our section and our legal community can deal with this important issue. We have an outstanding panel of speakers with us today representing a diversity of perspectives and experiences. You will hear more about them in a few minutes from our moderator. We are honored that Joanne Epps, the Dean of the Temple University Beasley School of Law, will serve as your guide and our guide to today's program. We're also very pleased to have Anthony Lewis, the author of Gideon's Trumpet, as our special guest. He was unable to be with us in person, but has videotaped special remarks for today's program, which you will see. But first, it seems appropriate that we meet the man who started it all and hear a little more about his journey that began here in Florida with a handwritten petition he sent from his jail cell to the United States Supreme Court. Ladies and gentlemen, meet Clarence Gideon.
Few Americans know this man, and yet he's an American legal landmark. He's not a celebrity, nor a member of the affluent society. He has spent a good part of his life in jail. He's a four-time loser. You might say a born loser. But once, just a short while ago, he took on the county courts and the lawyers and the wardens and the jails. He took on the state courts and the Supreme Court and the state governments and the federal government and the United States Constitution. And he hit it big. His name is Clarence Earl Gideon. He argued there can be no equal justice where the kind of trial a man gets depends on the amount of money he has. He argued there should not be one kind of justice for the rich, another kind for the poor. Gideon blew one note on his trumpet. He blew it over and over. A man cannot get a fair trial without a lawyer. And because he would not retreat one whit from that position, this man, Clarence Gideon, has wrought a profound change in the whole course of American jurisprudence.
CBS reports Gideon's Trumpet, the poor man and the law. Here now is CBS News correspondent Martin Agronsky.
This is the Supreme Court of the United States, the highest court in the land. The Supreme Court has often been a meeting ground for the confrontation of giants and giant issues. But it's not only the giants who bring their cases to this court. Here in the marshal's office, where the mail is sorted for the 9 justices and the clerks of the court, there arrived on the morning of January 8th, 1962, a large envelope. It came from Clarence Earl Gideon, prisoner number 003826, State Prison, Florida. Clarence Gideon's first letter to the Supreme Court asked permission to proceed as a pauper since he was behind bars and without funds. Gideon, who never had more than an 8th grade education and no formal legal training, was asking the Supreme Court of the United States to review his trial and sentence
on the grounds that I was made to stand trial without the aid of counsel.
On June 4, 1962, the Supreme Court sent to Mr. Clarence Earl Gideon a copy of the court's order of the day, announcing that he could proceed in forma pauperis and that certiorari had been granted. In plain English, the Supreme Court had decided to take up the Gideon case.
On the last day of that term of court, which I think was 25th of June, 1962, they appointed me an attorney, Mr. Abe Fortas. Fortas of Washington, D.C.
Had you ever heard of him, Clarence?
No, I've never heard of him, but a few people in there had heard of him. And
In Abe Fortas, the Supreme Court had chosen one of Washington's most prominent lawyers. Fortas had been Undersecretary of the Interior under Franklin D. Roosevelt. He was a close advisor to Lyndon B. Johnson. The Supreme Court, in naming Fortas to argue Gideon's cause, as usual, gave no reason for its choice of counsel. Fortas, like all lawyers, accepted the honor without question. He would serve without fee. He had never heard of Clarence Gideon and would never meet his client except through letters. But Abe Fortas knew that Clarence Gideon did not have the law on his side at that time.
The Sixth Amendment to our Constitution says that every man is entitled to counsel. That amendment, however, has been held by the Supreme Court to apply only to the federal government. With respect to the states, at the time of Gideon, about 37 of the states had similar provisions, but in 13 states, that was not so. I felt that the time had arrived when the court, with a proper case before it, would lay down the general rule applicable to all felony cases in the state courts, that every man, the rich, the poor, and the poor as well as the rich, was entitled to the benefit of counsel when he was defending himself against prosecution by the mighty forces of the state.
Abe Fortas for Gideon and Bruce Jacob for Florida were really arguing whether the right to counsel was a fundamental American right. Bruce Jacob, an assistant attorney general, spoke for Florida.
Well, we argued essentially the reasoning that was used in the decision of Betts versus Brady by the Supreme Court back in 1941 or 1942. First of all, we argued that historically, the Sixth Amendment, when it was first adopted, was intended to give individuals the right to retain or hire their own attorneys, but it was not intended to give individuals the right to have lawyers automatically appointed for them.
In the past generation, we as a people have been moving forward towards a better, a greater, and a nobler conception of the dignity of man, a more comprehensive conception of the rights of man. And I think Gideon is part of that movement.
On the 18th of March, 1963, the Supreme Court of the United States unanimously changed its mind about Betts versus Brady. 21 years before, Justice Hugo Black had been in the minority on Betts. But now, in the case of Clarence Gideon, he could speak for the majority. The court was wrong in Betts, said Justice Black. Any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. The conviction of Clarence Gideon is reversed. Clarence Gideon speaks for the poor man. Associate Justice Arthur J. Goldberg of the Supreme Court speaks for the law. Mr. Justice, do you find it curious, or perhaps I should say, do you find it wonderful, that a man like Gideon, in jail, should be able to bring about such a fundamental change in American law?
No, I do not find this wonderful. I find it required by our Constitution.
Mr. Justice, does the Gideon case solve the problems of the poor man in the law?
Well, the Gideon case is a great milestone. It solved a basic problem. Today, in all American courts, federal and state, when a man is accused of crime, he must be afforded a lawyer. If he can hire one, if he has the means, he hires his own lawyer. If he doesn't have the means, then a lawyer must be provided for him by the state or the federal government. But I cannot frankly say that it solves all of the problems, because when a man is called to the bar of a criminal court and accused of crime, he's presumed to be innocent, of course, under our system. And giving him a lawyer is only one step in what equality, truly conceived, requires. We can never overemphasize equality. Equality is, I profoundly believe, is one of the basic instincts of mankind. It's an ancient feeling that the poor and the rich ought to be treated alike. And therefore, it's an old tradition. When I took my oath of office 2 years ago, I took a constitutional oath to support the Constitution of the United States. But I took another oath, a judicial oath, an old oath of judges, which is given to judges the world over. And that is to do justice to the poor and to the rich alike, so that it's a pervasive concept that goes to the very central core of our judicial system. So Mr. Gideon stands free today after a trial by his peers because he enjoys the benefits of the constitutional guarantees of liberty and equality, the goals for which our revolution was fought, the goals for which our Constitution was written, and the goals for which all Americans must always stand firm.
1 week ago, Clarence Gideon visited the Supreme Court of the United States for the first time. He visited it as any tourist would, unrecognized. None knew him as the central figure in the historic case whose arguments had echoed in these marble corridors. That a man like Clarence Gideon could make the Supreme Court change its mind must stand as living testament to the vitality of American justice. But the harsh facts presented by the American Bar Association are that these states and 2,900 of their 3,100 counties still fail to provide adequate counsel for poor people in criminal cases. That the Gideon case has illuminated these weaknesses must stand as a continuing challenge to the American bar, the bench, the states, the Congress, and the conscience of Americans everywhere. This is Martin Agronsky for CBS Reports.
Thank you, Bill, for this opportunity to moderate this panel on this most important topic. In 1963, the Gideon decision struck like a thunderbolt, changing forever the landscape of indigent defense in this country. And here we are 50 years later to celebrate the decision and to assess its impact. A great deal of things have changed since 1963. We now have more than 1 million felony convictions in this country every year. And at 2.3 million people, the United States has more people in prisons and jails than any other country on this planet. Nevertheless, the American Bar Association, state governments, federal governments, independent organizations have all concluded that the indigent defense system in this country is under-resourced, underfinanced, and suffers from too many cases. Thanks to the Gideon case, indigent defendants in this country can now be assured the appointment of counsel. But we're here today to ask whether or not they are getting the effective representation our Constitution promises. Stephen Bright of the Southern Center for Human Rights offers an insight that might frame our discussion today. He said, "No constitutional right is celebrated so much in the abstract, but observed so little in reality than the right to counsel." I am joined today by 3 wonderful panel members. Dean Emeritus and Professor Bruce Jacob of the Stetson Law School, as you heard, argued the case in the United States Supreme Court for the state of Florida. Carlos Martinez is the elected public defender of Miami-Dade County. He's obviously got on-the-ground experience about the reality of the Gideon decision today and what it means to run an office that I think he will say is under-resourced and burdened by too many cases. And he's tried and will share with us today some creative and innovative solutions. And Anthony Graves. Anthony, thank you for being here today. Anthony was charged with capital murder. He was appointed a lawyer, but he was convicted and sentenced to death. He spent 18 years in prison, 12 on death row, before he was exonerated in 2010. And he will tell us about the real-world implications of our current indigent defense system. And as you heard, we are blessed to have a fourth panelist. I know it's not obvious. Anthony Lewis, the author of Gideon's Trumpet, was, as Bill said, unable to be with us today, but thanks to the wonders of modern technology, we are able to hear from him, and I'd like to start with a brief comment from Anthony Lewis.
Well, ladies and gentlemen, I'm sorry that I haven't been able to be with the panel. This subject means a lot to me and a lot to the audience, I hope, because I think it's terribly important. And I think it's something especially, I feel, that should resound in the hearts and minds of lawyers. It's what I think is part of the privilege of being a lawyer. I've always admired lawyers. I'm married to one, and I think it's a great profession, and this gets right to the heart of that profession, why it's great.
Bruce, I'd like to start with you and ask you to take your mind back 50 years and just briefly look back on the Gideon decision and tell us, sitting here today, what was most significant about that experience for you?
Okay, should we stand or?
You don't have to, but you can. I talk better on my feet. If that's true for you, feel free to stand up.
Well, for me, the case began in February of 1962. I was working in the Criminal Appeals Division of the Florida Attorney General's office, and the head of the office, my boss, Reeves Bowen, called me into his office and showed me a letter from the Supreme Court of the United States, from the clerk's office. Attached to it was a petition for certiorari, a copy of Gideon's petition. He said, "I want you to handle this case, Bruce." They were asking for a typewritten response to Gideon's petition for certiorari. So I prepared that and sent it in. And then on June 4th, the Supreme Court issued an order granting certiorari and asking the parties to brief and argue not only whether or not, under current law, Gideon should succeed, but also whether the doctrine of Betts versus Brady should be reconsidered. And that was the doctrine, based upon the Due Process Clause, that a person should have counsel appointed if the circumstances of the case were such that he or she could not get a fair trial without counsel. So the trial judge was required to inquire at the very beginning of a case on whether the defendant was too young to handle the case himself, inexperienced, uneducated, had mental problems, whether or not the issues were complex, and if so, the judge would appoint counsel. That was under Betts versus Brady. 13 states followed that approach, and 13 states and 37 states had flat automatic rules that counsel must be appointed in every felony case.
Could you tell us a little bit about the day of the argument, just as
Okay.
you look back on that right now? What was most significant about that experience?
Well, it was pretty exciting. First of all, I was at the ready table. There are two tables, one up front, and then there's a ready table for the next case. I was sitting at the ready table. Fortas had not yet arrived, and then our case, just as our case was called, Fortas suddenly appeared. I hadn't met him before. I had corresponded with him, but had not met him. He began arguing, and then the court took a break for lunch, and they led Fortas and me downstairs, one flight down, into a very small room, and we were the only two people there, sitting at a small table facing each other. And he talked about Justice Black, what a great justice he was, and he had handled a case for Lyndon Johnson when Johnson was first elected to the Senate. And Black was the one who decided there was a voter fraud issue, and Black decided that the state court should decide that issue, and so Lyndon Johnson became a senator for the first term. When I got up, I looked back in the audience, and there was only one person in the entire audience Anthony Lewis, by the way, was there. He was behind the bar with the lawyers, way over to my left with his typewriter. He was a reporter for the New York Times, and he was allowed to be inside the bar. But the only person in the audience, the non-lawyer audience, the other side of the bar, was my wife, Ann. Anyway, I began arguing, and the questioning was really brutal. I mean, just one question after another, and often there would be simultaneous questions from several of the justices, and I had a lot of difficulty in trying to figure out which question to answer first and how to answer it. Anyway, that's what happened at the argument.
Let me invite you to sit down, really. The whole idea was that you can stay seated.
Oh, okay.
I'm going to ask you one more question, if I can,
Okay.
before I move on. So the decision comes down and essentially requires that states provide counsel to indigent defendants. How did the state of Florida comply?
Well, to its credit, the legislature of Florida immediately passed a statewide defender law, setting up defender offices in each circuit. And of course, we have one of those defenders right here with us, Carlos. So immediately, there were defenders all over the state. Before that, there had been several defender offices in larger cities, but now we had one in every circuit. And that statute also provided that any private lawyer, and by that time I was in private practice, I'd left the Attorney General's office, any private practitioner could volunteer to be a quote, special assistant public defender. And on the day the law took effect, I went down to the courthouse and signed up. I may have been one of the first people to sign up to be a special assistant public defender, and I handled several cases in that capacity.
Thank you. Anthony, if I can, let me turn to you and ask you to introduce your case to the people in the audience. I have to say that in preparation for this, I thought that I was pretty knowledgeable about the state of the criminal justice system in this country, and I was really amazed by how much I didn't know and how dire some of the circumstances are. You were the beneficiary of the Gideon decision. You had a lawyer at your trial, right?
Well, yeah.
Okay, yeah. But we know that things didn't turn out as favorably. So I know about your case because I read about it.
Right.
Could you tell us, and I'd like you to sort of stop at the conviction part, and we'll talk about the exoneration later.
Well, first of all, thank you for having me here. Back in 1992, a horrible case had taken place in this little small county, and it was a whole family that was murdered. Crime of this magnitude had never taken place in a small county like this, and they were pretty upset. And they wanted somebody brought to justice. Matter of fact, the mayor come out before an arrest and said that whoever done this shouldn't even have a trial. They should just be hanged. And that's the way they proceeded, you know. About a week later, I was a knock on my door, and it was the police. And they was asking if they could talk to me. And yeah, fine, no problem. And they take me to the police station, and they charged me with capital murder. No pre-investigation, none of that. They just charged me with capital murder.
Had you heard about the killing?
I had heard about the killing because it was adjacent to my town.
Okay.
But, you know, I didn't even know the people. So it wasn't something that, it was like a sad situation. But when they arrested me, they took me in and they read me my rights and they charged me with capital murder. No investigation whatsoever. And so, okay, I'm innocent. So, I mean, I'm not upset. I want to make sure that whoever did it, they find them. So I'm gonna cooperate 110%, right? And I thought that would do it. That's not the case. I'll tell you, that's not the case because I cooperated 110%. And every time I did that, they said I was lying or they say other things. But the bottom line is I was okay because I knew that they're gonna have to give me an attorney. That's my right. I'm innocent, they're gonna have to afford me an attorney, and my attorney will come on, prove the case, I'll go home. That's television. It does not happen in the real world like that, okay? Especially when it comes to the public defender services around this country. Now, I know Carlos does great work, you know, but, I mean, Carlos is like a sore thumb sticking out when it comes to that kind of, you know, because when I got an attorney, and he came on, I mean, he came to me, he's like, man, I'm gonna fight for you, I believe in you, blah, 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 and I was happy. But what I didn't know is he hadn't never tried a capital case, you know?
Carlos, was your attorney appointed by the court or was your attorney part of an existing public defender office?
My attorneys?
No, I'm sorry, Anthony. I'm sorry, I said Carlos, but I meant Anthony. Was your attorney appointed by the court?
My attorney originally volunteered, okay, and then was appointed by the court.
I see, okay.
All right, and had very little experience. As a matter of fact, never even tried a capital case.
How long was your trial?
My trial lasted about 3 weeks. 2.5 of those weeks was brought out. 3 days of testimony. And I was convicted and sentenced to death.
Okay, thank you. What I'd like to do is turn to the present day more or less, because I think we could have an entire panel about what's wrong, but I'd like to talk about what's wrong today, if anything, so that we can figure out where some solutions lie. So, Carlos, I'm going to turn to you next, but before that, I think that this is a place where Anthony Lewis made some remarks that would tee this question up. So if we could hear from Anthony Lewis, that would be great.
When I wrote about the case in my book, Gideon's Trumpet, I said that the decision of the Supreme Court, powerful though it was, and important though it was, the actual impact of this on the ground is going to depend on developments that we can't foresee. It's going to depend on what states are willing to do by way of providing money for counsel and providing money for counsel to do a decent job. And a decent job is not giving one lawyer, shall we say, as a defender, public defender, or as an appointed counsel, 6 times what an ordinary human being can do, burdening him with cases so he can't do a decent job for any one of the 6. And we all know that a lot of public defenders and others representing poor defendants are overburdened, overwhelmed, in fact.
So, Carlos, please introduce to this audience your world. Tell us a little bit about what it's like to be the elected defender of what I assume is a gigantic office representing a gigantic district with enormous caseloads, and then we'll talk a little bit about what you've done in response.
In Miami-Dade County, it's the largest county in the state of Florida. It's about 2.5 million inhabitants, 25% of which are non-citizens. In Miami-Dade County, we handle every year about 90,000 cases, and I have 200 lawyers to handle 90,000 cases. So even the simple math, you'll do the simple math, and you'll see the amount of work that the attorneys have and the amount of work you can imagine that they cannot get to whatsoever in the time that they're given in those cases. But the problems in my office in terms of us being understaffed and underfunded pale in comparison to what's happening across the state of Florida and across this country, in particular with misdemeanor cases, which was one of the issues that came up in the Gideon decision, and later on it was addressed. But
can you stop for 1 second?
Sure.
I want to set the stage a little bit more. So you have 200 lawyers, and is that because that's all your budget will allow you to hire? I mean,
yes.
So we start with a money problem?
It starts really with charging decisions of the prosecutor. So, and actually before that, it starts with the legislature essentially making everything illegal. And when you have that, then you have the prosecutor charging, and then you get the public defender. So we don't get to pick and choose what cases we get. So the first problem is there are too many laws, particularly in the state of Florida, that should not be criminal laws. They should be civil offenses. They should not be criminal in nature because they do not warrant any jail time. So therefore, they should not be criminal in nature. So that's the number one issue, really. If you address that issue, you can get to the issue at some point of having adequate counsel. But until you address that, all we're doing throughout the time is just putting Band-Aids on it.
Okay, so you have 200 lawyers, 90,000 cases. I take it you're like most, as you just alluded to, courts assign cases to you. How do your lawyers deal with it? What do they do? I mean, that seems like a number of cases that would not just be difficult to do, but almost impossible to do well.
It is almost impossible to do well, particularly the lower level offenses is where the biggest problem is. we've essentially had to go to a model of emergency room work. That we have a lot of nurses, we have paralegals, we have investigators and other staff that assist in the preparation of the case, the intake of the client interview, and all sorts of things early on to be able to get it to a place where the attorney can look at the case and start working on the case. But it's a very difficult process to do. In 2008, what happened was the former public defender at the time spoke to me and said, look, we have a serious issues with caseloads. I want to file a motion to decline accepting new felony cases. Are you okay with it? Because at the time I was running for office, so he wanted to make sure the thing didn't explode in my face if I ended up winning, that all of a sudden I would have this big hassle. And I did agree with it. It was on principle, and it still is on principle. That was June 24, 2008. The case is currently still pending in the Florida Supreme Court for a decision. So we're going to have a 5-year anniversary cake on June 24th, and we have yet to receive any type of relief because the prosecutor interjected themselves into, because it's an ethical issue. The issue of excessive caseloads is an ethical issue, and it's an issue where the lawyer is saying, I cannot represent these clients because I'm giving up the rights of one client on behalf of the other because I can't get to all of them. So there's a conflict of interest, and we filed a motion essentially saying we cannot comply with our ethical obligations under professional rules of conduct because we have a conflict as we're picking and choosing which clients we're going to represent and when. When you look at the whole issue of the right to counsel, they're the purists that say it's government's responsibility, and it is. But the reality is, if you're the public defender and I'm elected to represent everyone, if I do not have government money to represent all my clients, I'm going to go where I can. So I went to the private bar, and it was a controversial decision for me to do it because other defenders around the state said, well, what if the state all of a sudden says that's how they're going to handle it? And my response was, I have clients now. I have to decide now. I have to look at this now. So the private bar stepped up in a big way. The civil bar, because I also went to the civil bar and I created a training program for the civil bar to help me on misdemeanor cases. So we provide training to the civil bar and they've been able to handle cases. And the best part with the civil bar, I think they have lost only one case because the prosecutors are scared of civil lawyers, particularly big firms.
Yeah. What are your thoughts about relieving the stress by getting volunteers and partnerships and all of the wonderful things that Carlos has been able to do? He's been able to serve his clients, which he might not otherwise have been able to do. But I'm wondering, doesn't it, as he suggested, doesn't it kind of let the government off the hook?
Well, it might, but I still think it's a very good idea. Back before Gideon, every lawyer I knew had handled at least one case, sometimes 3 or 4 cases on an appointment basis, every private lawyer. And they took great pride in that. There was a real spirit of volunteerism in the bar. My sense is that since then, since Gideon, we've lost some of that because I think now the average lawyer says, well, we've got a public defender office, let them handle it. And I think some lawyers would be shocked if a judge were to appoint that lawyer to a case. Judges have the inherent power to appoint in any case, and it seems to me we ought to get the private bar involved. There's a right way to do it, and Carlos explained the right way, and that is to have a really good training program and maybe start them handling misdemeanors and gradually work their way up and so on. But I think we really need to mobilize the private bar, use the private bar much more than we are at the present time, and certainly your office is really doing that.
If we're looking at a system that's under-resourced at the lawyer level, is the answer to go even further on the emergency room model? The nurse practitioner, the physician's assistant are doing in America a lot of things that 25 years ago only doctors did. Should we be going that way?
In other words, using the private bar?
No, using non-lawyers.
Using non-lawyers.
Using...
No.
Okay. Anthony.
Ask the guy sitting behind bars that, he'll tell you no.
Okay.
Yeah.
Because when you do that, you kind of water down the fair process. Okay, because you don't have the experience there anymore to represent that guy effectively. You know, you have a nurse doing a doctor's job. Okay, that's malpractice too, right? But I'm just saying, no, there's no way that you should go down that path. I mean, you really letting the government off the hook then. You know, I think the government should take a role. I think they should get involved. They should understand the problem that we're having here. You know, a lot of guys are being misrepresented who are innocent, who may be mentally ill, or who may be innocent of the charge, but not necessarily just innocent altogether. Those guys are not going to be represented effectively if you keep going down that path.
Okay.
You know, so.
Yeah. And the reality is that you can use non-lawyers if they're directed by lawyers. The problem in a lot of public defender offices, not just in the state of Florida, but throughout the country, the ones that have offices, because there are many places that all they have is low bid contracting. And that's no real lawyering at all in many instances. But you can use staff if they're directed by lawyers. But the problem is there isn't even enough money to have adequate number of staff. When you have so many cases and you're dealing, you're essentially dealing with work over and over again, and again, going back to the turnover issue. The turnover issue means that every case that lawyer has, that the lawyer left, the new lawyer that has to take it on, in order for them to be competent, they have to get reacquainted with the case. They have to go back and talk to that attorney, to that client. Even if they have great notes, even if they have great work done, they still have to redo a lot of things. So it's not a very efficient process that we end up doing. We end up spending a lot of money on training. We end up a lot of time just churning cases. And a lot of people don't even realize the impact that has on victims. Now, most of the time, you're not going to hear a public defender talking about victims, but victims also have a say in terms of when their cases go to trial. And if you have a situation where the government isn't adequately resourcing, whether it's the state attorney's office or the public defender's office, you have these cases lagging for some time and justice is not done. So it's not just Anthony that doesn't get exonerated promptly, but it's also the victims that don't get to find out, hey, they got the wrong guy. That's right. In our caseload litigation, one of the most interesting facts that came out is I was complaining because my lawyer had 155 pending felonies. 155 pending felonies. The corresponding prosecutor had 300 felonies. Now, how our legislature or even our prosecutor did not stand up and scream, I was hoping that she would join us in the litigation, because if I got extra money to be able to hire lawyers, the way Florida works is every dollar the prosecutor gets, public defender gets 50 cents. Good. So it would have been a boon for them. But the prosecutors, even though the function is different, they don't have a client and they have the police to do the investigation, it is unconscionable that a prosecutor has 300 felonies. Just like a defense attorney having 155 felonies is nuts.
Right. One of the things that I was struck by when I was preparing this and depressed by the state of indigent defense around the country, and some of the anecdotes are really truly horrifying. I was wondering whether what is really happening is that there's just a lack of caring.
The hardest questions for lawyers, I think, and their friends are always asking them, how could you represent this terrible man? Well, just as the First Amendment protects people's right to say very unpleasant things, so I think the counsel provision of the Constitution, the Sixth Amendment originally, and the Due Process Clause of the 14th Amendment, protect the right to have a lawyer whether you're guilty or innocent. But the right is the right to be represented by counsel so that can be determined in a more rational way, a fairer way. And that's fairness is all.
My sense as an educator is that people still go to law school because they want to believe in a system that is fair and just. And yet I pose the question as to whether what is really infecting our criminal justice system is at some level a lack of caring. So let me ask you first, Bruce, your reaction to that question. And then Carlos, I'm going to ask you whether, if you think it's true, you have trouble inspiring people to come your way. But Bruce first.
Yeah, the public doesn't really get excited about helping criminals or people. look at as criminals, people who have committed crimes. So they're not willing to put the money into the system. And the legislature, of course, does what the people want. They don't want to put a lot of money into a defender system.
Yeah, it's the reason I asked the question a little while ago about using non-lawyers, and I actually agree with Anthony. I think the answer is I don't want to go that route, but if we are in an era where governments do not have enough money, or at least that's what they think, they're going to cut back places. And so one of the things that I hope we do in the second half of this program is think not just about the problems we have, but what we might do to solve them, because what we have to ensure is that what happened to Anthony, and I'm going to come back to you in a minute, we have to make sure that doesn't happen to other people. But at some level, as Carlos said, he protects people in your circumstance because he's got a spectacular capital unit. And maybe the give is at the bottom where you're looking at somebody who isn't facing jail time. So we really have to ask ourselves what some of the solutions are. But so let me turn, Carlos, and ask the question to you. If, as Bruce just said, we live in a world where people don't really care too much about helping people who are accused of crime, how do you get people to get inspired and excited?
I don't have a single problem getting people inspired to come work for the public defender. But I want to jump a little bit onto the issue of, what is it that you do? We're about to have this whole discussion on cutting back on entitlement programs at the federal level. And yet we're not looking at the state level where we have a jail and prison entitlement program by legislators. They feel they're entitled to put everybody in jail, put everybody in prison, put everybody on probation. That's where I'd like to start cutting. And the general public, and what I found when I was running for office, it was really amazing, because it's a very different view from being an assistant public defender to actually running to be the public defender, even though I had been close to the elected public defender and had gone with him when he ran before. What I found that in Republican circles, Democratic circles, everywhere, people do have a concern for the right to counsel because they know people who have been affected by it. They know people have been affected by it. And they know the right to counsel when it comes to issues of substance abuse and mental health, because it's very prevalent. So that is a way to be able to engage the public in that discussion. And the public generally gets it. The public, to me, is ahead of the politicians in knowing we have gone too far in criminalizing way too many things. But in my office, I attract the best from around the country. We recruit all over, we recruit nationally. And I am in awe of the quality of young lawyers that come into my office for $42,000 a year. That's not much more than what I got when I started, 22 years ago. But there's a tremendous amount of passion. And with the youth of today that are coming out of law schools, they come at it with a view that is phenomenal, that actually fuels me, because when I see them fired up about injustice, when I see them on a Saturday, 7, 8 o'clock in that office, because I'll come by on the way somewhere, and I'll stop by and I'm like, what are all these cars doing out here? And these lawyers are putting in tremendous number of hours, learning the craft, learning from others, and giving of themselves. There are a lot of caring people in the system, prosecutors and judges alike, but everyone is numb by the crush of cases. Everyone is numb. So when we had our litigation, frankly, when I looked at how bad things were, our numbers really told the story. But then when people spoke, when one of my attorneys spoke, it really hit home. But what you have is you have overburdened prosecutors, overburdened judges, and everybody is focused on processing cases. So when we raise the stink because there's a dirty little secret in the criminal justice system, and it's called pleas at arraignment, or pleas before any workup has been done by the attorney, whether it's interviewing the client, whether it's doing the independent investigation or doing anything, that's the dirty little secret. If we stop doing those, the system would halt. So the whole Gideon case is meaningless if you don't need an attorney to advise a person before they take a plea, before they accept a plea. And that's the challenge that we have in the U.S., that, you know, we have become a system that is so dependent, it's, you know, on all these pleas, that it's just amazing that we have so many of those that are pled out without the assistance of counsel. Because even if you have an attorney standing next to you, which was the issue that Anthony was mentioning, he had an attorney.
Right.
But that attorney was not competent to represent him. The attorney didn't do the work. That is no different from one of my attorneys being in court and not having the time to be able to investigate the case. There is no difference. So that's the challenge that we have. We have the first challenge, which is all the courts where people are not represented. We have the challenge where the attorney is overwhelmed by the work. And then we have the challenge where the system keeps pushing cases through and thinking that it's okay to do those pleas, which have an attorney next to them, but they're essentially uncounseled pleas.
Anthony, so you're with us. So obviously something wonderful happened, and so this is now your moment. Can you tell us the second half of the story?
Well, the second half of the story is what I'm doing now. But, yeah, what happened? I'd like to go back and speak on something that y'all had mentioned.
By all means.
We were talking about sharing information, saving money and stuff like that. I think that should be a law where prosecutors and defense has to share information so that when that defense attorney is no longer on that case and another attorney comes on that case, all the information is available by that prosecutor. I think that should be etched in stone. Prosecutors should not be able to hide work evidence by calling it work product. Okay, they should be have to turn it over. Now they say, well, we have a law for that. Well, it's not defined right. It's not specified.
Right, the Brady, you're talking about the Brady.
The Brady, I'm
right?
talking about the Brady took my life. I mean, my freedom and almost my life.
Right.
And I am saying that there should be more of an onus on prosecutors to turn over evidence.
Well, it's
to
interesting.
share evidence with the defense.
At least for those of you who don't do criminal work, we were alluding to Brady versus Maryland, which is a case that imposes on prosecutors an obligation to disclose exculpatory evidence. But
yes.
as Anthony will describe to us, that doesn't...
But they get to define...
Right, it doesn't ensure that it happens.
Right, they get to define what's exculpatory.
Right.
You know? I mean, it's like asking the fox to go in the hen house and protect the hen, right? But as far as the second half of my story, it started when...
So you get convicted and...
I got convicted. I was sentenced to death row. I spent 12 and a half years on death row. I had 2 execution dates where they was telling me that they was going to kill me and wanted to know what I wanted them to do with my body and what I wanted to eat as a last meal. And I didn't pay attention to all of that because I was still, you know, I'm innocent and I still believe that at some point justice will prevail. How? I didn't know, but I went and I wrote a letter every day to somebody, asking them to help save my life. And then, you know, this wonderful, wonderful lady named Nicole Caceres. She's a professor at University of St. Thomas. She was working, volunteering with the Innocent Project, which anybody who has volunteered to do work on these cases, I commend you. Mm-hmm. I commend you because that's what you took your oath for, okay, to serve and protect. Anyway, with me, like I said, I was down there 12 and a half years with 2 execution dates, and Nicole came on my case as a volunteer. And this lady stayed with my case for 8 years. She went through every up and down with me. When they were telling me that they were going to kill me, when they denied my appeal, she was there. She didn't get paid, but because she believed in the work that she was doing, she went above and beyond the call of duty. And as a result, my case was overturned because this woman got out there and she really turned over every rock for me. And my case was overturned and I went back to the county jail. I was thinking that I'm finna go home, it's over with. The guy that lied on me, that already executed him, they didn't have nothing to say Anthony Graves was involved in this crime because, as a matter of fact, his dying declaration was that Anthony Graves was an innocent man. He's an innocent man. He had nothing to do with the crime. You know, he said that over and over and over. Everybody said, well, he said it when he was on the gurney. Yeah, he did, but he also said it the same night he lied. But we didn't know. Prosecutors never turned that over. They were willing to allow me to go to death row knowing that I was innocent and be executed. Yeah, we have a big problem with not caring as well. And politics. Politics has replaced justice in our justice system. It is all political. Which way is the wind blowing? Okay, what is the topic of the day? And it is watering down our system. When I went back to the county jail, as I said, I'm happy and I'm ready to go home. And I got there on a Friday. That Monday I was supposed to go to court. My whole family was going to be there, and this is over with. It's going to be a celebration. And I get there, and when I get to the court, the judge that I now have is the daughter of the judge that sentenced me to death, who's now refusing to get off the case, even though we've asked her in the interest of fairness. She's not getting out of the case. And she pushed that case for 4 more years.
Oh, jeez.
She kept me in jail, put me on a $1 million bond without a bond hearing, and pushed that case for 4 more years trying to find whoever she could to come back and re-prosecute this case. I went through 10 prosecutors. They would come on the case, learn the case, and get off the case. But they were too coward to do the right thing. And then finally, I run across a lady named Miss Kelly Siegler, who is a hard-nosed prosecutor. She put like 19 men on death row. She's put more men on death row than some states. And they went and hired her, and it's true. They went and hired her to come and put me back on death row. But the good thing is that Ms. Kelly Siegler, she wanted to not only put me back on death row, but to make sure that the I's were dotted and the T's were crossed so this wouldn't happen again. So she started doing due diligence. She really went into the work. And she went from, okay, can we try this case, to, oh my God, this man is innocent. Okay, and that's when she called my attorneys. Well, no, let me digress. She went to the judge and said, Judge, this man is innocent, and we need you to sign this release order. Wow. And the judge said no. This was the judge, this was the daughter of the original judge, and she said no. And they told her, look, if you don't sign this order, we're going to go to the press and tell them that you got an innocent man in there that you're refusing to let go. And reluctantly, she signed the order and said, well, let him go out of the jail because I don't want him in my courtroom, right? Because they wanted to schedule a hearing for me and my family to be there, and they apologized to me, and she didn't want that. But that's okay with me, right? So October 27th, 2010, I was sitting in my cell and I was writing a letter to a journalist, Miss Pamela Koloff, who wrote an extensive article on me in the Texas Monthly Magazine. And I was just writing to her, and I was talking to her about the prosecutor they just hired, Miss Kelly Siegler. And I was saying, oh, she's just going to throw stuff on the wall and try to make something stick, but that's okay. I'm innocent. I'm going to continue to fight. Either they free me or they kill me. I'm not compromising anything. Right? And then the sheriff came to my cell, and he told me, hey, come go with me. And I said, why I'm going? Because I was hungry. I want to eat. He said, just come on, go with me, man. So I put my shirt on, and we're going down the hall. And I noticed we didn't take the right turn, which is where the client and attorney meet. I kept going straight. And now I'm getting paranoid, because I've always heard these stories that, when they know you're innocent and you've exposed them, they try to make it look like an attempted escape. They kill you, you can't talk, So I'm paranoid. So I'm saying, where you taking me? He said, well, just keep walking up. I said, man, I'm not going nowhere without my lawyer, okay? I know this now. I know about Gideon now, okay? So I'm not going nowhere without my lawyer. So finally, he recognized my paranoia, and he opened up the door, and that was my lawyers. And so when I walked in, I'm thinking that they're just going to update me on what's happening because there had been some activity going on in my case. And my attorney, she stood up and she asked me, she said, Anthony, you remember when you told me that God was good? And I'm like, yeah. But in the back of my mind, I'm like, well, what they got to do with it? I'm hungry. I want to eat, And she says, well, God is good, Anthony. Ms. Siegler just dropped the charges against you. And I was like, this is 18 years. Okay, I've been battling for 18 years. So I'm in battle mode. I didn't even hear this, but then I said, "What did you say?" And she said, "Yeah, they dismissed the charges, and you free to go." And I said, "Well, what do I do now?" Because I was scared. And the reason why I was scared, because I had dreamed that dream for so many nights, only to wake up behind bars again. And I'm thinking that this is just another dream, that I'm going to wake up and I'm going to still be here. Or they just gave me some wrong information. They're just going to take me somewhere to the infirmary and bring me back. So I was afraid to even believe that. And by this time, an officer walked in and he said, "Well, Mr. Graves, would you like to get your property out of your cell?" And I said, "Yeah," but it wasn't even that. I was just so discombobulated because they telling me I can go home after 18 years. And so we go down the hall and they said, "Well, okay, you want what property do you want?" And I said, "I don't want nothing. I just want to go." Right? He said, "Well, don't you want your legal stuff and your pictures?" I said, "Okay, yeah, but everything else y'all can keep. I'm ready to go before somebody change their mind." So we walking back down the hallway, and they walked me outside. They walked me out the side door, and people said, "Why did they walk you out the side door?" I said, "I don't care. Any door would have been fine for me." You know what I'm saying? You know how many years they closed these doors on me? And so I'm walking out the side door. And 48 hours, I guess they had, I don't know how they found out, but they were there. And the first question Richard Schlesinger was asking me, he said, "So how do you feel? How do you feel, man, being out after 18 years? And this was October 27th, and the sun was shining. And I said to him, "It's hot out here." You know what I'm saying? I've been in the building, right? And so he said, "Well, do your mother know?" And see, you got to understand, my mother didn't know. First of all, let me just say this. See, when cases like this happen, it has a ripple effect. It doesn't just affect the inmate. It affects his family. I watched my children grow up without me, that I can never get that back. I watched my mother health decline, worrying about her son that she knew was innocent. Nobody has said they're sorry to them. My mother and my family was on death row for all those years with me, and nobody apologized to them. So this thing has a ripple effect. But when he asked me, did my mother know? And of course she didn't, because it was just 2 hours prior when they made this decision. So they was like, "Well, call your mom. And they give me the cell phone, and I said, "I don't know how to use no cell phone." Because when I went to jail, you had the big cell phone. You plug in, and you talk, and they cross your arm and leg, right? So now I'm coming out, and you got this little old phone that you can reach around the world with, and they're telling me, "Call your mom." I don't know nothing about this. So my attorney, she has my mom's number, and she said, "Well, I'll call her." And see, here's the thing. When I was in the jail the last 4 years, I was in total isolation. They didn't want another inmate talking to me. Didn't want them looking at me. They just had me behind double doors, still double doors. I had no communication with nobody. I had to rec by myself. I had to go to visitation. Whatever I did, I had to do by myself, because they were caught, and they were trying to make me suffer. Okay. So what I could do was use the phone. It costs a lot, but I could use the phone, and I would call my mother almost every other day. And one of the first things I always asked my mom when she got on the phone was, "Mom, what you cooking?" And she would tell me, right? And then after she tell me, I would say, "Now, why you tell me that?" She say, "Well, you asked." I said, "Yeah, but don't tell me." I'm sitting over eating this bad food, and you gonna tell me you got steak, and don't tell me that. So she said, "Well, okay, next time I won't tell you then." So the day I got out, and they asked me about the phone, and my attorney called my mom, and I hear her voice, "Hello?" And my attorney said, "Well, I have somebody here you want to talk to." And she handed me the phone. And I said, "Mom." She said, "What?" I said, "What you cooking?" She said, "Why?" And it was the first time in over 18 years I was able to tell my mom, because I'm coming home. And see, that was the work of good attorneys. That was the work of attorneys who volunteered because they believed, you know. And so I would ask, I don't know anyone out here, but if you're attorneys, and if you're in a position that you can make a difference in somebody's life who has been wrongfully convicted or who has been incarcerated and he's mentally impaired, or whatever the reason is, Nicole Caceres, my attorney, can tell you there's no greater feeling than you having something to do with a man regaining his freedom and a family bonding again. There's no greater feeling. I don't care how much money you ever make in your life. You're never going to have that feeling until you experience it, and you're going to realize that is the true richest of the rich. It's helping others. I know this. It's why I do what I do today, and it fulfills me. It gives me a purpose in my life that I'm helping others, and I am blessed beyond. So that's my story, and I say, please get involved.
Well, I was going to talk about what we can do, and you have just done that. I am going to ask them to play the last Anthony Lewis clip, and then I'm going to ask Bill Bay to come back up and close this program.
Some of my friends think I'm too much of a romantic about lawyers. And I am. Along with the romance comes obligation. But I don't think it's a tough obligation. I think it's a wonderful obligation. A lawyer who ordinarily would never see the inside of a criminal courtroom, who deals with important matters of constitutional law, of other matters, or most lawyers deal with issues of money. Who gets the money? Who divides up the contract, or how the thing falls? The chance to actually commit yourself to saving another human being or to the defense of another human being, I think is a wonderful thing, and the greatest thrill of being a lawyer. And I don't make that up, because I've seen it with actual lawyers who say to me when they've stepped out of their ordinary lives and take on a case of this kind, and win or lose, it will say, it's the most wonderful thing I've ever done.
Bill.
I said this would remind you of why you went to law school. And I think it does. It's amazing stories. Anthony Lewis, who's shown the light on the case. Honorable Carlos Martinez, who's on the front line of defense every day and telling you about the real life stories. Bruce Jacob, one of the things he said was, being a young attorney arguing against Abe Fortas. And yet the first thing he did after the case came down, after he left the Attorney General's office, was to go volunteer to represent an indigent defendant. And Anthony Graves, wow. I mean, the amazing thing is he wasn't telling us a story from 1963 or 1983. The date was 2010. When he was exonerated. He says, I know about Gideon now, and God is good. He was entirely correct. In the end, the attorneys were good and diligent and did the right thing. I think that's what we need to be about. Thank you, Dean Epps. Thank you, our extraordinary panel. Let's give them a round of applause. Our panelists will be here for a few minutes to meet with you. The section of litigation has a long tradition of excellence in programming. We hope you will use the many other resources we provide to litigators. And if you are not a member, we urge you to join the 60,000 members who are members of our section. Thank you for participating, and this will end our programming. Thank you.